I have brought with me good news and bad news. The good news is that we got, finally, a Court of Appeals in the United States to tell us who is responsible for maintaining the oil record book. There have been many prosecutions, and they were based on a regulation of the Coast Guard that read as follows. It was very plain. The master or other person having charge of a ship is required to keep an oil record book, shall be responsible for the maintenance of such record. There it is. Many prosecutions were conducted under this regulation that defined things. In a trial, it seemed to us that we had defending a chief engineer. It seemed to be a bit nebulous. So at the conclusion of the state's evidence, we asked for a verdict of acquittal because the regulation under which the chief engineer was being charged was a bit fuzzy. Didn't say the word chief engineer in there. The Court of Appeals for the Fifth Circuit agreed with us in a case of United States v. Fafalios, and it held. Chief engineers on foreign flagged vessels cannot, however, be prosecuted simply for having previously failed to maintain an oil record book once a ship enters U.S. waters, since the regulation assigns that duty explicitly and exclusively to the master or other persons having charge of the ship. So, the government cannot use the chief engineer's oil record book to get to your company. The bad news is that we're working at cross purposes with some companies who insist in their SMS manuals to make the poor chief engineer responsible for maintaining the oil record book and thus expose themselves to being fined because the liability of the company is vicarious. It is through the person that is responsible to maintain that this company is liable. Where do the writers of these manuals get this information? We don't know. MARPOL, Regulation 17, doesn't say anything about chief engineers being required to maintain oil record books. It says that the person responsible for the transaction is supposed to enter it and sign it. It says that each operation described in paragraph 2 of this regulation shall be fully recorded without delay in the oil record book, part 1, so that all entries in the book appropriate to that operation are completed. By contrast, and I don't know if you can see it clearly, this is an excerpt from a safety manual or engine manual from a ship's SMS. And in the next one, it's spelled out clearly, the chief engineer is responsible for ensuring that all engineering records are properly and accurately maintained at all times and for reporting to the office on a regular ad hoc basis. Guess what is the argument that the government will make if we tell them that, look, we prevailed in the Court of Appeals and the chief engineer is not responsible for maintaining the oil record book? They'll tell us that under company policy he is, so the company is responsible. As we said, the liability is vicarious. The company is responsible for acts committed by its employee in the course and scope of his employment and for the ostensible benefit of the company. My advice to chief engineers and companies is don't have a chief engineer write a monograph from top to bottom completely of an oil record book. Have those officers who are responsible for doing the transfers or other transactions record them and sign them. Along similar lines, another thing that we find very frustrating and exposing companies to MARPOL-APPS liabilities, criminal liabilities, is the use of certain non-controlled documents on board the vessel. And in particular, there is a thing that is called a sounding log. I don't find in most SMS manuals a controlled document by this name. Yet, they're ad hoc documents, they're maintained on ships at the initiative, sometimes of chief engineers. The company doesn't know about them, and it is the single most important piece of paper that is used by the Coast Guard, by the Department of Justice Environmental Section, to build a case against the company. Why? Because invariably the contents of these sounding logs are dissimilar to what the oil record book records. They're not coordinated. It's natural that they are. But many a prosecution, I'm aware of 3 or 4 prosecutions in which this argument is advanced by the government to prosecute and successfully convict. Why would you need to maintain a running record of showing how much oily water you have in your bilges every day? I can understand if it is bunkers, I can understand if it is lubricants, but why oily water? Waste. Isn't the record of the oil record book sufficient? It is important to keep track of what is going on your ships from shoreside for the technical department and to review the oil record books. But the correspondence that leaves the office and goes to the vessel, you have to be very careful what you write, because your email correspondence is not private. Because if there is a prosecution initiated, there's an investigation initiated, the first thing that the Coast Guard will do is image your hard disk that contains the correspondence with the office. Very innocently, someone in some office had suggested in these emails to a chief engineer that your oil record book is not credible. The figures you have in there are very low. Guess what the government did with that statement? It's the company that dictates to the chief engineer what to write in the oil record book. The company is tangled up in this thing. The company is liable. Again, on the caution that you should use with email correspondence that can be used for prosecutions, as evidence in prosecutions. There's an example of, from an actual case of an email in which the chief engineer advised the office that needed a spare and could not work the incinerator. A week later, and the ship was at sea. A week later, and I note he mentioned incinerator not working. A week later, that's a copy of the oil record book. In the second entry, if you can make it out, it's burning, even though it is inoperable. There were 7 incidents of burning like this, 7 separate incidents, 7 separate false entries, $500,000 each. It never came to that because the Coast Guard did not catch it. We caught it, even though we didn't represent the owners in that case. If you go in the United States and you anticipate you're going to have Port State Control come on board, by all means, get this publication It is a circular written by Captain Carr. It tells you the scenario that the Coast Guard will follow in doing a MARPOL inspection, which is part always port state control, at least a very simple MARPOL inspection. It is online, and it's very easy to access. I've translated it into Greek. I recommend that you use this. It will give you exactly what will happen, and your people on board the ship will know exactly what to anticipate. You should be prepared when you call for a MARPOL examination. Never allow your ship to go in an American port having in open storage spaces devices like this, or events like this. You see, this is oily water piping from the bilges that was freshly painted about a week before the ship called in the States. That giveaway for something going wrong for the Coast Guard, anyhow. I hope that I alerted you, gave you a few hot tips